I know. Welcome to the March meeting of the steering committee of Community Board 7. We have quorum and we can begin. I'd like to hear a motion to approve the agenda.
So moved.
Second.
All in favor?
Aye.
Thank you. Starting with a very, very brief chair update. Two things. First, at 6:34 this morning, a 7+ pound baby girl was born to Josh Coughlin. So he will not be here this season.
But his wife will. His girlfriend.
But we certainly congratulate him, as I'm sure everyone here should be excused. So there's that. Secondly, we are looking, we've heard from the borough president's office, we will be getting 7 new members in May. And we look forward to that, and we'll keep everybody in the loop as and whenever that information surfaces. So that is my report, district manager's report.
Thanks. Mine is less brief. So following up on my email from earlier today, I saw 5 of you signed up so far for the tabling event on 4/3. Check that email out and sign up if you can. Next, I want to plug the rat mitigation zone agenda item at Health and Human Services next week. That should be an interesting agenda item presented by DOH. And then Beverly wanted me to share kind of what we do for, or what we're planning on doing for training of new board members, kind of as a takeaway from the survey. A lot of people were wondering what we do and what the plan is. So I'm just going to go through the list so everyone knows. So first, there's a social event that's going to be under development. I think Roberta said she might be taking the lead on that. But as far as the trainings, what we do
Roberta has also offered up Madge.
Roberta and Madge, or maybe this is new to everyone. I guess we can talk about that after then. So what we do is we start by having a quick Zoom meeting.
Hang on for Kevin this one.
Yes, sounds good. So during the initial Zoom meeting, I go over the website and how to find things, finding resolutions on Airtable and past minutes on YouTube. I go over the structure of the monthly meeting calendar and their general commitment level, which is 2 committee meetings and the full board. I encourage them to shop around, as Beverly does as well, to kind of show up to each meeting for the upcoming month to kind of see what ones pique their interest. Then I let them know who to reach out to, whether it's me, Jesse, or Alex, based on certain things. I share access with them to the handbook, board contact info, and then answer any other questions that they might have. Based on the conversation at that point, I then connect them with certain board members if I think there's a topic of interest that might align with them. And then I ask if they want a Google Drive training or a Zoom training. And if so, I bump them over to Jesse or Alex who will do that. And that's pretty much the extent of our training so far. Then Beverly also meets with them and provides additional information, and they start landing on the shores of our various committees as well, where you'll see them. So, and I think I heard earlier that they're not getting appointed until early May. So a little further out than we thought. That was my report.
What was the tabling thing?
Oh, the tabling thing. It is for Gail Brewer's open house. I'll send it to you if I didn't. I thought I did, but it's on April 3rd, but I'll send it to you.
That's Thursday.
Okay.
Yeah, I think so. Yeah.
We will then move on to our first substantive item, amendments of discovery rules. We have several folks who wish to speak about this, explain the legislation, several pieces of legislation that are perhaps necessarily not the same, that are in Albany at the moment. And also, I know Saralee will also bring some wisdom to bear on the same matter. Go ahead.
No, yeah,
Turning it over to Doug.
Yeah, no, I mean, Beverly just put it exactly the way I would say it, is that there are some suggested tweaks to discovery laws that were passed in 2020, that are suggested to make it up to the, well, I think it was passed in 19 and implemented in 20, if I'm not correct, but the experts are here to explain that. And there's some suggestions of tweaks that may be helpful by preserving the rights of both the accused as well as victims. And also, as Beverly mentioned, there's another bill that is sponsored by Michael Asher and Myrie in the Senate, which perhaps in some view is on parallel tracks, maybe complementary, but I'm not the expert at it. I thought we were really honored to actually have folks from Micah's office as well as the DA's office. Whomever wishes to go first would be great. Can you describe perhaps whichever first, the Micah's bill or the DA's suggestions?
Can we have people move forward so the mics can pick them up better?
Yeah, because we're streaming, so we definitely want you to be heard from people that are
Do
tuning
we
in.
need to move some chairs?
Would you like to sit?
Yeah.
So please, our potential speakers, please join us around the table.
Ms. Claire Botnick, the Chief of Staff, Michael Asher, and Amber Strickland, who is, I believe your title of is Attorney in Charge of Criminal Court at the Manhattan District Attorney's Office. Correct. We're honored to have you both here. And of course, Julia Mazza, who we know and love with DA's office as well, who's not a stranger to our.
Thanks, Michele.
Who would like to go first?
Sure, I'm happy to kick off. So it's a privilege to be here with the steering committee. Thank you, Doug, for the kind invitation to be here. Michael would have loved to be here himself, but he is up in Albany. And I look forward to the discussion. I'm here to present on a narrow proposal, which is intended to address some learnings that have come out of the last several years in doing this work in the courts every day, conversations with the DAs and with the defense bar about what's working and where there could be improvements. And so one of the things that we learned in the course of trying to understand how things are going with the discovery law reforms that have been put in place is that there is a tremendous burden on the district attorneys and a time crunch to comply with their discovery obligations, and that there are certain administrative and procedural hurdles that kind of exacerbate those burdens and could be tweaked so that people have readier access to the evidence so that they may comply with their discovery obligations under the law. And so this is a narrow proposal that is intended to help bridge procedural gaps. Oftentimes, we think we have to think really big to make transformational change, but sometimes the fixes are very, very small and modest. And I think that this is an example of one of those. So here we've learned that direct access to the police department's database for certain sets of discovery and evidence that are needed by the parties in order to proceed with their cases cause big backlogs and cause waste and drain tremendous resources for both the police departments and the prosecutor's offices. And so in order to ameliorate that point of friction, we have proposed a bill, which is A825, that is intended to grant district attorneys access to certain NYPD-based databases so that they may directly access, in collaboration with the NYPD, some of the files that they need in order to comply with their discovery obligations. So some examples of this are, and this may sound silly, but sometimes a case could rest on getting this kind of information. Certain chains of custody reports, which would be very, very important, and which can be a big holdup and would allow DAs to directly access those from the NYPD. And then also something that sounds like a very long report to me, which would be like body worn camera logs and the battery pack reports as to whether they were charged or not. So something as sort of technical as a battery pack report could be the reason that a DA is or is not able to comply with their obligations under the law. And so this bill is really intended to make it easier to access that information, improve collaboration and coordination between the DAs and the NYPD, and to make the system of justice move smoother so that defendants can have all of the evidence that they're entitled to under the law afforded to them in a timely fashion. So I'm happy to take any questions, and I look forward to discussing.
Is the bill written for New York City only, or is it a statewide?
It's a statewide. Yes.
Is there any downside to this?
This proposal has been endorsed by the Legal Aid Society as well as some of our partners in the DA's office. So I think that there is consensus that this is a change that we need and that would be helpful. I think sometimes people think that the collaboration between DA's offices and NYPD is self-evident and that why wouldn't they be easily able to work together and to collaborate, but we've learned that it's a sticky point, and so this is intended to address that. Yes.
Is this retroactive or proactive or how is it?
Forward-looking.
It's forward, all
Yes.
forward.
Yes.
Ken has a question.
Yeah.
I think Michele has a question. We'll go to Ken first and then.
Are there any other states that are doing this? Have done it already?
That's a good question. I don't know the answer to that off the top of my head, but I will certainly look into it.
Michele.
Does the bill enumerate those documents that the DA's office
Um,
will be able to get from NYPD?
No, it does not. It does not go through any of the specific. I think there are some specific examples. Let me just refresh my recollection,
Okay,
and I'm
sure.
happy to provide.
Anybody else? Well, I'll just say that I have heard anecdotally, and maybe anyone can chime in on this, that and I'm not an attorney, but I'm told that characteristically, the discovery rules and laws in New York State are among the most strict in the United States of America. And that I've been, perhaps I don't want to steal anyone's thunder, but some of the tweaks that are being suggested by both the DA's office as well as Michael Asher's office and Myrie, even with those changes, we would still have the most strict discovery rules in the United States of America. Is that, I'm seeing heads shaking. No, I don't know. I've heard it anecdotally. So.
Okay. Jamie's our attorney, so.
Yeah.
I just wanted clarification. What do you mean by most strict?
Well, I don't know. I've heard it anecdotally, so perhaps, the DA's office could explain that.
Saralee has
So
a-
I'm not a
Sarah- yes,
criminal
Saralee,
defense, I'm not a criminal defense
Yeah.
lawyer, I am a lawyer. There are many cases in which the failure to turn over discovery by the prosecutor in a timely fashion before this 2019 change in the law culminated in a person's being wrongly convicted because discovery was turned over at the 12th hour, right before the trial. And not all discovery was turned over. So I don't know whether the rules are strict, were before the change, or not strict, but they resulted in some wrongful convictions, and that's not good. So you can call them anything you want, but you need to have good results. And perhaps, some changes were needed,
Sure.
but I'm not sure it serves any purpose to say something's strict or lenient or whatever.
It's a fair point. Is there anyone else that has any questions from the committee or non-committee? If not, and if Claire, if you want to add anything, and that perhaps this is a good time to introduce the DA's office and have them present their suggestions.
Happy to. Thank you all for having me here tonight. Like was said, I am the attorney in charge of criminal court, so I supervise all of our misdemeanor practice in Manhattan, which is where we're seeing a lot of the discovery issues play out on a day-to-day basis, just because of the volume of cases that we deal with. I'm going to try to just do a brief overview of all this. I do want to save a lot of room for questions, but I do want to make very clear as we start that pre-2020, there was certainly a need for reform. The laws that were in place did allow prosecutors to wait until the eve of trial to walk into a courtroom, hand over piles of discovery to the defense, and that was not a fair or just system. So we needed reforms. Unfortunately, the 2020 reforms are a bit overbroad and have shortened the time frame for us to provide this material to the defense. And it is a system now and will continue to be a system where we have some of the most transparent discovery laws in the country. And I think that might be some of what has been alluded to of the current system. And even with the reforms, we are still allowing a lot of access to the defense, which is as it should be. A defendant should know what they're charged with and what the strength of the case is. But I do also just want to clarify as we start, discovery has sometimes been summarized as the evidence in the case. And when we're talking about discovery, some of discovery is evidence. It's the photos, the videos, the medical records. But then we're also talking about administrative documents. So the battery pack document, that's a more administrative document that's not really going to go to the defendant's guilt or innocence, but is a document that we have to get under the current law. And unfortunately, we are seeing cases dismissed for those minor administrative documents. In 2020, some of the reforms, what they did, like I said, they brought into the scope of what we needed to get, and it also presumed that prosecutors had everything that law enforcement had. So the proposed bill coming out of Assemblymember Lasher's office and also in the Senate does move the ball forward for us. It would give us direct access to some of these materials. Unfortunately, it doesn't give us access to everything because there is a lot that's still done in a paper system in the NYPD, which is why I would ask that you consider supporting the governor's proposal as well. And I'll touch on some of those changes in the proposal. One of the other issues with the 2020 reforms is while it brought into the scope of what we needed to provide, it didn't really define some of those documents. So one category is any material that would challenge the credibility of a witness. And obviously that's important. We want to know whether or not an officer is someone who has a history of being dishonest. But unfortunately, there's not clear guidance in the current law of what that material is. We can get a document from NYPD that says this is the history of the officer's disciplinary proceedings that were brought against them. It lists the date of the allegation, the nature of the allegation, whatever the outcome was. Some judges will say, great, that's enough. Other judges will say, no, you need to get the IAB logs that say this is the investigation we did into this officer and this is what we found. Other judges will say, that's not enough. You need to get any evidence in the IAB investigation. So if an officer was asleep in their patrol car, a person from the community takes a photo of that officer, gives it to IAB, some judges will say, as a prosecutor, you have to go get the photo of that officer, even if it's from an incident that happened 5 years before this case. And we're seeing cases dismissed for that. So the lack of clarity is a current issue that we're seeing. And a lot of the impact that we're seeing from the 2020 reforms is unfortunately a lot of cases are getting dismissed. And this is obviously impacting public safety. We're seeing it, like I said, a lot in criminal court. We do have a fact sheet that I can pass around in a bit that'll run through these numbers. But if you're looking at data from the Office of Court Administration in 2023, the overall dismissal rate of all misdemeanors and felonies in the city was 62%. That was up from 42% in 2019. If you're looking at just misdemeanors in the city, in 2023, it was 74% were dismissed, up from 49% in 2019. So big jumps in dismissals. And then for just felony offenses in the city, the dismissal rate in 2023 was 44% compared to 28% in 2019, a significant increase. And these dismissals aren't just numbers. We're talking about if you're looking at a domestic violence case, that is a case where the order of protection goes away as soon as the case is dismissed. So some of the most vulnerable people in the community are left without that added step of protection. And domestic violence cases can be very challenging with discovery because the case doesn't just stop from an NYPD side once an arrest is made. Officers will go back and do home visits and check in to make sure that there aren't violations of the order of protection. And every time they do that, there's more paperwork, there's more body cam. And if the prosecutor doesn't know about that and doesn't get those documents, cases are getting dismissed. And then one of the other things that we're seeing with dismissals is it's impacting how ADAs are spending their time. And I can speak to this definitely from an anecdotal sense as being a supervisor, direct supervisor for 2 years prior to my current role of overseeing all of criminal court. But ADAs are spending a significant amount of time chasing down paperwork. And some of it is a very significant piece of paperwork. We need the detective's case file. Some of it is a more minor piece of paperwork like the body camera issue. And Anytime an ADA is making the decision, okay, I have this many hours in the workday, I'm gonna spend this chunk of time on discovery, that's time that they're not spending investigating the case and meeting with the victim, talking with people from the community. And it's also leading ADAs to make the decision of what cases do I prosecute? My docket has 100 cases in it. I only have so many hours in the day. Which cases am I going to say are important enough that I should get the discovery on or try to get the discovery on? And that's not a system that anyone wants. It's not fair to anybody because cases that ADAs aren't working on, they're still lingering in the court system. They'll get dismissed once speedy trial has passed, but that case is still pending when we could have resolved it sooner if we're able to get the materials in the case. And I will actually just briefly touch on the fact that the 2020 reforms tie discovery to speedy trial, which is part of the issue. So for misdemeanors, you have 90 days to prosecute a misdemeanor. Felonies, you have 180 days. The current statute ties discovery to that time frame. If we don't get the discovery in 90 or 180 days, the case is dismissed. If we do get the discovery, but then find out after that time frame that we missed a document, that we missed a video, the case could get dismissed. One of the proposals in the governor's budget is to separate that, to say that there could be other remedies than just outright dismissing a case. And that would be based on the proportion of the harm caused. So what's the document that was missing? How much discovery was turned over? Let's do a thorough analysis of these issues and decide what the appropriate consequence is. Let's not make it an outright dismissal. So that's one of the main proposals in the amendment. And one of the issues that has been brought up by the defense bar for this specific proposal is that it's putting the burden on the defense. But the reality is the current law says the prosecution has to turn over anything related to the subject matter of the case. So the prosecutor is making the decision. This is everything related to the case. Here you go. The current system then puts the ball in the defense attorney's court to look at the discovery and say, is this everything or do I want to challenge it? Then a judge makes a decision about whether or not to dismiss the case at that point. So that's the current structure. The new structure under the governor's proposal doesn't really change that. It just changes how much we have to turn over by saying what's relevant to the case, not what's related. And when you think about it, that does shrink the universe a little bit, but it certainly doesn't put us back in a pre-2020 world of prosecutors could wait till the last minute because we still have to swear under oath on a signed document that we've given you everything. And now we can move forward in the case. It does, I think, put us in a situation where the case can move fast or can move forward sooner because we're saying in this universe of what's relevant, we've given it to you. We're saying we're ready to go to trial. Tell us if we missed something. Is there an issue? Let's talk about it. The judge will make a decision instead of waiting for everything related to the case, which takes a lot longer to find. And then let's have a conversation. And that's where we're seeing the maybe unintended consequence of the 2020 reforms of the current system allows the defense to wait to challenge the discovery. We can say, here's everything. The defense can wait until speedy trial time has passed and then raise the challenge to discovery. And that's honestly good for them because there's no remedy but dismissal at that point. But the proposed amendment would allow those things to be separated to say, let's look at what wasn't turned over. Was it just about the battery pack? Does this actually harm the defense in any way? If it doesn't, fix the issue. Let's continue moving forward. If it does, you can still dismiss the case. So it doesn't cut out that remedy. The other change in the amendment is that it would define the subset of materials. Like I said, the current system says what's related to the case. The amendment would say what's relevant, which does shift the universe a bit. And then the final main change is that it would require the defense to file a timely motion to challenge the discovery. Under the current system, the defense can wait. Like I said, the amendment would say 35 days after the prosecution has said, here's the discovery, the defense has 35 days to challenge. So that would keep the case moving, would allow us to not see cases lingering, which is good for everybody. The longer a case lingers, the more the victim and defendant are both in an uncertainty. Victims have to still be available to the DA's office as long as the case is pending, which isn't a good system for anyone who's been harmed. And then also just on a community level, when we see cases linger, we don't have the deterrent effect of swift and certain justice. There's no remedy. We're not being able to connect people to services sooner, and cases are just lingering. And that's where I think we're seeing a lot of the recurring crime and a lot of defendants who are repeating through the court system because we're not able to intervene early. So that was a flyby of the history and the proposed amendments. We do have a digital copy of a sample resolution.
Get that up.
Maybe we can put that on the screen.
Yeah, give me one sec.
And I'm happy to answer any
Should be
questions.
signed off by CB with XXX.
Julia sent me a.
Oh, good, okay, oh, perfect. That's
The definitive one, I think.
Yep.
Yes.
Oh, great.
That'd be great.
Thank you. Oh, yeah, that'd be great.
That's what I was hoping.
Yeah, I think I showed enough for everyone.
Sure, we can pass it down if that's easy.
So
we do that
We, we have some
Oh, well, yeah.
questions here. I think Ken.
Okay. Two questions. One, if you could, if it's not on the paper, if you could just go through the 35-day thing again.
Yes.
And also, I assume that you're contending that most of the increase in dismissals is attributable to the discovery changes?
Yes, so I can't say this absolutely, but I think when we're looking at the increase in dismissals, what we're seeing are, one, judges dismissing cases when we've missed a discovery item. Two, we're seeing ADAs just not able to get all the discovery. And then three, ADAs are choosing not to prosecute certain cases because they're trying to handle the discovery on others. So whether or not it's a direct judge saying you didn't do it, discovery does impact it. On the 35 days, the amendment would add language that the defense has 35 days after the prosecutor provides discovery to challenge the discovery.
And what is it now?
There's no time frame in the current section. Yes.
I have two questions. First, who determines what's relevant in terms of the information that's brought to the case? Is that the judge? Is that enumerated within the law? How does that all work? And my other question is 35 days enough time for the defense to file, I guess, a petition, a motion? And how is it done in other states or jurisdictions?
Sure. So as far as who determines what's relevant, it is broadly laid out in the statute of different categories of 911 calls, photos, scientific reports, but ultimately it would be the prosecutor deciding, but then they would be checked by the judge. And that's where the system still currently is. The prosecutor's deciding what's related, and then they're checked by the judge later. Is 35 days enough time? I think it would depend who you ask. With the discovery, we do have to provide a list of what we're giving over. So a table of contents saying, here's detective so-and-so's DD5 file, here are photos, videos. So there is an index to go through it. And for most of these cases, people now know what's out there in the universe of material. And I do think that puts us in a different situation than we were pre-2020. I think if you asked your average prosecutor or defense attorney pre-2020 what materials the NYPD had, I don't think anybody had a good sense. And in 2020, everyone's eyes were open to the types of documents they create. So now I think it is a lot easier to just do the quick look. And the way the motion practice functions, if a defense attorney made an argument about a part of the discovery, but maybe didn't fully understand the nuance of some of the materials that were missed, they could file a reply and we could still address that.
Sarah, you had a question?
Let others, I have a
Oh,
lot
sure.
of things.
Adam has.
Two questions. The DA's office is endorsing everything that the governor put in her budget in terms of discovery reform.
For the discovery issue, yes,
Okay.
we're endorsing.
Second, can you speak to why this only seems to be an issue in New York City and other areas have not seen a massive increase in dismissal rates. Because that seems to be a big issue to me, that seems to be a New York City specific issue. And we haven't seen this issue in our other jurisdictions.
I'm not the best person to speak to that. I have guesses that I could make. I think the volume of what we're seeing in the city is a huge factor. The number of cases that we have is huge. NYPD does function differently than other law enforcement agencies, and the amount of documentation that they produce, I do think, is potentially exponentially greater than others.
So you can't say this, but I can say this, that I think the NYPD is probably the reason that there's a difference between New York City and elsewhere. So I was wondering, could you speak to the amount of stuff that would, I don't know how familiar you are with Micah's bill, but would that be, 5%? Would that be 50%? Open access to the NYPD records, I imagine, would help. And I'd love you to talk about to what extent you think that might ameliorate some of these situations in New York City.
Sure. So I do think it would help. I'm not going to put a percentage on it, but there are the basics of the case that would be covered by direct access to the electronic files. So in a detective case, the DD5s, which are the detective's notes, the attachments, that would be great to get directly and not have to wait for it to be shared with us. All the body cam stuff, that would certainly be covered. Unfortunately, there's still a lot of documentation that the patrol officer is just writing down by hand and someone has to scan and send. And I would say maybe 45% of what's coming through on an arrest is going to be material like that. And that's where I think we may still run into issues of, unless we're getting a system where all of that is automatically scanned and sent, things are still going to get missed.
Question.
Daria?
So, why would you, I understand that getting direct access will be able to facilitate getting the data that you need. How would that have been solved by putting deadlines on discovery, turning over the discovery? Does that not work at all when the judge comes down and says that based on the discovery request, this information, this data needs to turn over by a certain time? That's just not being met and there's no repercussions for that. Is that the reason why you need direct access? Why would it not be solved by just having them have a deadline for turning over discovery?
The NYPD to the prosecutor?
Mhm.
I don't know if that would solve the issue because there are different lanes that we're in.
Okay.
NYPD they're handling the investigation, the arrest, they're then really handing it off to us. And so there are some challenges in this applies beyond discovery, but in having a shared understanding that everything that they're doing is tied to what ultimately happens in the rest of the case. So a judge could say directly to a precinct commander, you need to tell your officer to give us this. But the way the system is currently structured, the prosecutors kind of fit in between of we have law enforcement, then the prosecutor, and then the court. So it's really the court just talking to the prosecutor, and we could turn around and say to the officer, we need this, or the case is going to get dismissed. And you have individual officers who are moved by that and detectives who are moved by that and will work overtime without getting paid to get us that material. But then there are just the realities of they're overworked too, and they can't get us everything that we need.
So that shifts the burden to the ADA to go and kind of go get the,
Yes.
the hard documents and then go into the system. Are there firewalls in place for you to access the correct one? Because part of the whole discovery process is they know exactly where they can go and what they can access, and they can do it very quickly. In this process that you guys are doing, are you going to have like safety protocols up to make sure you're accessing the right data? And working directly with the PD on that? Yeah.
I think the way the bill's written is that there's read-only access pretty much. We wouldn't read-only
Read-only.
access. So we wouldn't be able to go in and alter anything. It does, I'm not sure what the specific mechanics would look like of what you could access, of if it's just, here's the login information, and then one ADA could look at everything in NYPD. I can't imagine that would be what's in place. I will say though, as far as officers getting discovery now, they're not always the best people to know this is where something is, because if you think about a patrol officer who makes an arrest, and then you have other officers that might handle the property in the case, something goes to the lab, there's a lot of moving pieces, and the way the NYPD functions is you're really just in control over your own domain. So a patrol officer may not actually know, where am I going to get the chain of custody from?
Got it. Thank you.
Claire, do you want to say something? I
The only
see
other
Shelley
thing I
has.
was
Yeah.
gonna say with regard to the timeframe question, which I think is a smart question, is the balancing of police resources to meet those expedited deadlines. And so the idea here in an age where we have constrained public safety resources as a starting point is, how do we want to manage that burden? And is, just syncing access of more efficient way rather than additional man hours, the additional cost that comes with that in order to comply with a tighter timeframe.
I think Shelley has something.
Yes, really, to both, question to both. In formulating legislation and supporting the governor's and other attempts, was the NYPD consulted in this process, number one? And number two, is there a need for additional personnel in the NYPD who could do this more efficiently and more effectively?
On my end, I don't know what conversations were had with my office and NYPD leadership about it. As far as increasing personnel, I know they already have to some extent. We have discovery liaisons within different precincts who work with liaisons in the DA's office. So there already has been a buildup. I do think there comes a point though, both on an NYPD side and a DA's office side, of how many more people should you hire to try to deal with this when there might be cheaper solutions with like direct access.
Okay,
Saralee has.
yeah, so, thank you. And I had hoped that we'd have somebody from the criminal defense side, and we didn't get someone, so someone asked me the other day, but I'm not a criminal defense lawyer.
But I am.
All right.
Okay.
No, go ahead.
Oh, I'm sorry, Jami,
So,
you had your hand up.
all right, so
I
Saralee.
had a very basic
Sorry,
question.
Sarah, please go ahead.
Me?
Yes.
Okay, so the Law Journal had a wonderful article on February 24th. And what it is, essentially the title of it was "Not a Minor Amendment," which is what the DA's office says. Law professors urge New York legislature to reject the rollback of discovery reforms. And it appears that 80 law professors joined with the New York Criminal Defense Community Advocacy for leaving the 2020 discovery reforms undisturbed. They included law school, Barry Scheck from the
Innocence Project.
Innocence Project, lots of people that are very impressive. But what they said is this is a complete change and going back to the bad old days, and notwithstanding the DA's characterization of the changes, they are very dramatic. In the course of my looking at this thing very briefly, I came across a case called People versus Bay,
Yes.
which is a New York Court of Appeals case, which was decided in 2023. I don't want to go through it, but it does describe a terrible thing that the prosecutor in that case did, which led to a bad decision. And it wasn't the police who held back the discovery in that case, which caused the case ultimately to be dismissed. It was the prosecutor who didn't give up materials that the defense lawyer kept saying, "Don't you have it? Don't you have it? I need it." And the judge said, "Well, he says he doesn't have it, so he doesn't have it." When the defense lawyer asked a different prosecutor appeared on the case shortly thereafter, he said, oh yeah, here, have the stuff. So it's not at all clear that either side, the defense or the prosecutor, are really wonderful individual people. But things happen, and you can't have a system wherein one side or the other, it could be the defendants, as you guys say, they wait till the end, the last minute, and then the speedy trial problem happens. But it seems to me there are a lot of problems on both sides. And going back to a system that didn't work up until 2019, regardless of whether you say it's just little changes, it isn't. And even the common sense change thing that you gave out says that there are so many more dismissals, and you cited the numbers and the percentage of them, but there's nothing in here that says that they're due to the new discovery rules. And clearly you said that that's one part of it, that there are other things. I'm thinking, I don't want to be so argumentative, I think I sound so, that we need to hear from both sides. I know from Doug tonight that one of the reasons we're moving ahead, or they want to move ahead with the model resolution, is that the state legislature is acting shortly and we want to get something in before. I sometimes think that haste is not the best way to proceed. If at the end of the day, the district attorney's resolution should be supported, we should do that. If there should be some adjustments, then we should do that. If Michael Asher's bill is something that we should support, but from what you say, a lot of it has to do with mechanisms rather than underlying philosophical issues.
Absolutely, I would think of our bill as a narrow slice of this conversation.
So that's easy, okay. So we
Low-hanging fruit.
we could support you and have some questions about the rest of it.
And if you want to respond, and I see Jami's hand was up, so I want to make sure to acknowledge.
Jami's-
But I want to give you an opportunity to.
Let me hear the response.
Yeah, if I could just briefly, so I think I've definitely heard the criticism that this would put us back to pre-2020. I don't think that's a fair characterization of it, because pre-2020, and I practiced in criminal court and Supreme Court pre-2020, there was never a requirement on the prosecutor to certify that they had provided the discovery. You would get to court and say, yeah, I gave the discovery, but there wasn't the burden of you are signing your name to an affirmation as an officer of the court, swearing that you have complied with your obligation. And that's not saying that everybody who does that has done it, because we do have cases like Bay, which they missed a significant and obvious piece of discovery. But I think Bay is helpful in one way, that it does lay out a little bit more of how to analyze the diligence of the prosecutor. There are some that say, let's just let the courts handle this. Appeal cases when they should be appealed, we can get more decisions from the courts giving guidance on the law. That only works to some extent, and it is a very slow process. And even with Bay, you have judges interpreting Bay differently. And so if you're in Manhattan, one judge may say, this is how Bay applies, that I'm looking at diligence on how you tried to get every single item, not your diligence of the case as a whole. If you're in Queens, Staten Island, Brooklyn, Bronx, depending which judge, it could be a different result. And so that's not a just system to really leave it up to the whims of a judge to decide if the case survives. But while the law or the amendment would change from related to the case to relevant, which is a significant change, where related to the case is a massive universe, relevant is smaller, it does still allow all the mechanisms to stay in place of allow a judge to make that decision. Did we give everything that's relevant to the case?
I'm sorry. So the DA makes the decision about whether it's related or relevant, whatever the thing. Isn't that a problem? I mean, that the criminal defense lawyer only gets to start with whatever the DA thinks is either related or relevant. I mean, that's a problem. Shouldn't they have to give anything that seems like it in some way related?
And that's where I think the 2020 reform tried to land, of saying related really means anything. And that's where we're seeing the problems of, if you're saying anything, that could lead to us digging for a long time to try to find what is the bottom that we're trying to get to as well.
And the DA shouldn't have to do it. There are paralegals, and if you need more resources, I think we should have a resolution about that, actually. Because it seems to me you shouldn't be, the lawyers themselves have to appear in court and write the papers and try the cases. They shouldn't have to start looking through files.
To some extent, there are a lot of prosecutors, myself being one of them. If you're putting your name on it, swearing that you did everything, you don't want to leave it up to some other folks. There are some things that you want to make sure you touched every piece of paper in the case. So we've hired more paralegals and analysts, which have helped. We are trying to look at more systemic changes within systems that we can do on our end to try to meet this burden, because we don't want cases dismissed. It is horrible to have to call a victim in any case and say, I'm really sorry, but the case was dismissed because we missed this item, whether small or big. And there are some cases where big things are missed. I do think there are some people, and this is true for any side of the system, some people might act in bad faith. I also think there are a lot of people who just are human beings and miss things.
Right.
Did anyone else have any questions? I know Jami, obviously. Jami, well, you're next.
No, I feel satisfied with what I've heard. I mean, I do think there's, the massive power and machinery of this. First of all, I'm a huge fan of Alvin. Let me just say, just saw him at Gail's Town Hall, went up, you saw me talking, I'm a big fan. And I really appreciate the post-2019, post-2020 willingness of DA Bragg and others nationwide to think differently about how we approach the criminal justice system. And I say that as a criminal defense attorney who always wanted to work with law enforcement and the other side of the bar to get it right, whatever that meant. We call it an adversarial system, but I like to think of it as a collaborative system. That being said, especially when you're talking about a force like NYPD, the biggest in the world, a small army, and a powerful district attorney's office like the one you have, it's a massive machinery and very powerful, up against also overworked and under-resourced criminal defense attorneys, public defenders, legal aid, as you mentioned. And so I do concern myself always with whether or not defense attorneys are getting what they need to do right by their clients. And I always assume good faith, though I've run into a lot of bad faith in my career, and on both sides of the bar, right? But I like what I've heard. I would like to hear from someone from you mentioned the criminal defense bar and how there has been some pushback, and I wouldn't mind hearing about it, but I also understand that time is somewhat of the essence. And I really thank you for the presentation and yours as well.
Yeah.
It's important stuff to get right.
Do we have any other? Yes, we do. And also anyone online, but.
Does the defense benefit from this as well?
No.
Mhm.
I would say I think it will move cases faster, which I do think benefits the defense.
But don't they sometimes get information this way that they didn't have before?
Yes, but I
shouldn't
think
they have it if it's evidence?
yes, but I don't think the governor's amendment would take away things that they need for their case. And I also think, to be honest, because the can has been opened of what exists in the universe, that we're now all more informed players in the process. We know what's out there, and so there can be better conversations. And just to touch on the 35 days, again, in the governor's proposal, it does include language for you have 35 days to challenge, but a judge can find that there's good cause to extend that.
But to be fair, correct me if I'm wrong, what I understand this proposal suggests is that in 2019, 2020, there was an overcorrection. And now what this is attempting to do is pull back a little bit and recorrect, that's a word, to recalibrate so that there's a more even playing field in the discovery arena, right? And those in the defense bar would say, well, there's so much power on the side of prosecutors and police. We didn't overcorrect. We were correcting for a system that has been balanced against us for 250 years, or at least 50 years, 100 years. And so there was no overcorrection. There's no need to recalibrate now. I'm not saying that's my perspective. That's what I've heard from my friends and colleagues in the criminal defense bar. And they would not use the word minor about some of these body battery pack and body cam footage and that kind of thing. So it's really a matter of perspective, right? Is that not fair?
That's fair.
So just to put that perspective out on the table because it's not present here tonight.
So I know we need to move this forward because we have other agenda. Roberta, you had your hand up.
I just want to point to the resolution.
Yeah.
CB7 no longer uses whereas we say the
Yeah,
following
that's-
facts are taken into.
Yeah, this came from the DA's office. We can clean that up, but I think Adam, and does anyone online have their hand up? No?
No, just.
Adam, you had
I think it's
another,
just-
I was gonna, I didn't have a question.
something to say or? no?
Yeah, I was gonna say that I do, based on the conversation, based on the timing, I do not think we should move forward with a resolution on the governor's budget proposals with regards to discovery. And maybe we should, if we want to do something in time for the budget, maybe we should look at the bill that Myri and Micah have. But I don't think that we should move forward on the governor's proposal.
In characteristic, because you don't think that we've heard enough from an oppositional side, or you're just, you've already heard enough and you're against it personally?
I think both. I think that it would be, we've had someone from one side who's done a very good job articulating their view. And I think it's very clear that they have a strong view. But I really think we need someone from the other side who can talk about that, the idea that, I don't know who's had the chance to look at the governor's budget, but in the discovery reforms, it would now allow prosecutors to redact all sorts of contact information of folks who are going to get called to trial. And that may seem like a little thing, but that's a huge deal for the defense to know who's planning to come. So I know that the DA's office, and again, I respect them a lot, has an agenda here. I would like these changes, but I really don't think that these are the changes that we need to make. And I come back to kind of the question I asked earlier, which is, for whatever reason, and I think the answer is the NYPD, this has only been a problem in New York City. Other counties do not have dismissal rates doubling at the same rate. So I personally think that we should take the approach of, well, let's do some reforms with how the prosecutors are able to access data from the NYPD. Let's see if that helps and makes a difference. And then let's try to come back to this. I think we're all super aware of the horrible travesties in the past of people stuck on Rikers. And of course, everyone on Rikers is innocent because no one has been convicted, right? And that's why we made this big, no, well, they are innocent. That's why we made this big change to the discovery laws, and I would hate for us to go back on that.
So,
Why don't we do like a show of hands as to who wishes to move forward, right?
yeah, I mean, look, first of all, at a minimum, I want to say thank you to everybody that weighed in, and particularly the Assembly Member's Office and the DA's office, because I think no matter whatever resolution we come to, we've elevated this conversation. I think it's a very important one. This is in the local news, this is in the national news. And I personally, this is just me, I support the governor's proposals and the DA's initiatives, as well as Michael Asher and Myri's bill. That's me. So I would like to propose a resolution supporting it. Now, we also could bifurcate it. So just, I guess, from a straw poll point of view, is that fair to say? How many people would like to move forward with a resolution, whether you're for it or not tonight? And I'm gonna put my hand.
Which one?
Well, I mean,
Let's bifurcate.
okay, so if we want to, if we want to bifurcate it, then I guess let's talk about the DA's suggestions, which are the more meaty ones in terms of, volume. Who would be prepared to vote, on that issue tonight?
I have a question, sorry.
Okay.
When we're talking about time frame and the governor's proposal versus the legislative proposal, are they on the same time frame?
Well, I can I think Claire can speak about it. My understanding is this is happening in April, and that's kind of why we're just discussing it.
So
And we
for
know
both
that the budget hearings always get extended, but I think time is of the essence if we want to weigh in one way or the other. But I don't know. I mean, perhaps I can ask anyone, what does the timing look like here? If we held this over for another month, would we lose our opportunity to weigh in one way or the other? Or do we have another month that we can get someone from defense and hear things out in more detail?
I think we should assume that the governor's budget will be locked by the very last, hopefully not past the second week of April.
All right, so that,
That's the realistic way.
so that would be
Yeah.
But,
past our full board.
but if
budget.
something doesn't make it into the budget, it can become a legislation.
Yeah.
That's voted on later.
It's separate.
But very unlikely.
It's separate.
Down New York State.
So, so having.
Sorry, I should just say, to your point, our bill is not on the same clock. Our bill is in the session and is moving through the process, so not the same time.
But as the governor's,
Yes.
okay, got it. So that's helpful. So, I would be comfortable moving forward with a resolution supporting both the state, the DA's office, as well as the assembly. But if we're bifurcating it, I'm just gonna ask the question. This is a straw poll, it's not an official vote. How many people would be comfortable voting on a resolution on the governor's proposed tonight? And I'm gonna say, I guess I'm the only one. Okay, how many people would be comfortable voting one way or the other on Michael Lasher's bill tonight?
Can you just reiterate that?
Okay, that,
This is just a bill that's been introed this session, so we will be, it will weave its way through the process, and would hopefully be by June.
But it's the same thing that.
No, it's not the same.
No, what is it? That's
Oh,
my
this is,
question.
sorry, this is the more narrow bill that addresses some of the operational concerns related to the ability of prosecutors to access the databases of the NYPD in order to expedite the discovery process, so.
log into their computer, read only. And Ken
It
has a
would
question.
move
Yeah.
us forward. So we support that.
Yeah.
We'd just like a little more.
I'm just wondering, has the defense bar taken position on
Yes.
your bill?
Yes, we have the support of legal aid on this proposal.
Okay,
And
right,
have
you
heard
said-
from others. in the-
So that sounds like an easy one. Now, I even though we may lose the opportunity to have community board vote one way or the other on the other initiatives, I'm going to ask that in a future meeting to be determined that we do have someone from defense come and we can further discuss it and decide if we want to support or not. But I caution all of us that we may lose the opportunity to weigh.
That would be great, but can we have this nice person from the DA come back at the same time?
That's up to
So
her.
so she
Nice to
can
have
say
them both.
something.
Yeah, it'd be good to have them both.
I mean, we want to have a balance. no?
Right.
I'll defer to whatever the board would like. We have been at some community boards where both someone from the DA's office and legal aid have been present. So yeah, we're happy to, in whatever capacity you want us to appear, we're happy to.
Okay, Roberta.
I'd like to make a motion that we vote on the legislation.
Second.
Yeah, okay. All right, so, that motion is, I guess we don't really need to vote on the motion, right? I mean,
Yeah, we have to on the floor.
So on the floor, so all those in favor of supporting Michael Asher and Senator Myries' bill in the Assembly and the Senate respectively, all those in favor?
All steering committee members.
All steering committee members.
Steering committee
So-
members,
You have Seema as well.
Yes, and who is?
1, 2, 3, 4, 5, 6. Oh dear. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, 14, 15, 16. I think we got 16.
Do you have Seema?
Yeah, any opposed? Any abstentions? Anyone ineligible?
And we do non-committee members.
And for non-committee members in favor? One? Who else online? I think, okay. So non-committee members opposed, some abstentions and eligible. All right, so that means that obviously we're gonna move this to full board in April. And I will commit to work with everyone here and who wishes to get some other resources and invite you back. I'm sorry we couldn't do it all tonight. The timing is the issue, right?
We
We
could,
really appreciate all the attention to detail and the response to all of our questions.
very helpful and
Very
informative.
helpful. And like I said, we, at a minimum, have elevated this conversation and it's important one.
Thank you so much.
Thank you.
I appreciate your time.
Was that
Thank you.
16 or
16.
Thank you. 16.
Provide our guests, and they'll be right back.
Okay. All right, well, let's move right along. The next item is one that is brought to us by Kevin. Regarding, yes. An equity resolution. Do you want to introduce your item?
Yes, thanks, Beverly. So as we know, the Trump administration, one of their first executive orders is to force organizations, both public and private, to eliminate rollback DEI. So in chatting with a lot of my neighbors and people in the community who are very upset about this, I think we as a community board can make our voices heard. As you know, the New York City pension plan is the third largest municipal pension plan in the country, managing $280 billion of assets for some of the people in this room that rely on that. So the essence of the resolution is focused on three areas. It's about a workplace equity, it's about inclusive practices, and it's about fairness and meritocracy. Those are the elements of this resolution. And so there's been supporting evidence by McKinsey, the Harvard Business Review, as well as other highly reputable organizations that show that organizations that have inclusive cultures that are diverse deliver better operating and financial metrics than those that don't. And since the job of the New York City pension plan officers is to generate an adequate return for its retirees and beneficiaries, we're proposing this resolution. There's three parts to it. First, we're encouraging the ecosystem that the New York City pension plan operates in to encourage workplace practices of fairness, meritocracy, and equity. And then the second element of this talks about continuing to support emerging managers. So emerging manager are asset management firms, other organizations that are part of the investment management ecosystem, such as investment managers, consultants, brokers, investment bankers. These emerging managers are women-owned, minority-owned, veteran-owned, and the list goes on and on and on. And this is something they continue to encourage. So it's pretty much in a nutshell. I think it's not only good for business, it's the right thing to do. Roberta?
I think it's excellent. I just want to point out again that
The whereas is.
we take out the
Yes,
whereas.
yes.
We'll
we can
fix it.
change that.
We'll fix
May
it.
I point of inquiry, why are we so opposed to the whereases? They add structure.
We
and
started
clarity.
out about 7 or 8 years
Wasted
No,
ago.
I
ink.
know, I understand that, but since I'm new, I'd like to understand why.
I can
Because
explain.
this adds clarity and.
I was
order.
trying to explain.
Please, go ahead.
So about 7 or 8 years, I think it was while Elizabeth was chair.
I remember.
But we had a communications committee that we were involved with, and it's difficult to read. The following facts were taken into consideration, makes it an almost easier read. And so it was voted on, and that has been our manner of writing.
But that's really cosmetic at this point. We should worry about the content.
Exactly.
I have a question.
Kristen, yeah.
So who is it addressed to? It's
It
to,
is the two people, the New York City comptroller, as well as the chief investment officer, whose name escapes me, of the New York City Public Pension Fund.
okay, thank you.
Just at first blush, it seems that meritocracy and equity are at cross purposes. So can you explain how they mesh?
Yeah, I pushed very hard to have meritocracy in there. I think the current efforts to end DEI nationally have claimed meritocracy as theirs and their whole rationale behind it. But the whole, if you know the history of DEI, if you know the history of the effort to avoid the biases that used to be, and many still are, present in the hiring markets, and in who gets promoted. Those are not based on historically based on meritocracy, so that if you lose a DEI program, you are less likely perhaps to have people subjected to understanding that they do have to essentially treat applicants with equity. So I think that reclaiming meritocracy as part of the whole equity argument is a very important move for us to make.
And I would also add, the far right have said that DEI is not based on meritocracy.
Right.
Exactly.
That's the other part of it. And we're saying
It
It is.
it is.
It definitely is.
It absolutely.
So Tammy,
Yes, so I agree with what Beverly said. I think the idea of having to take, positive or affirmative action to establish equity means you get a meritocracy, meaning because people are biased, if you don't take efforts to make sure that they are being equitable and unbiased in hiring practices, investing practices, then you won't get the best people or invest in the best companies, right? So that's the difference there. That's why they're aligned.
So I get why, I mean, obviously think this is a great step forward for us to do. But I'm wondering sort of why you chose the investment officer or the controller and not things like the school, other entities that impact,
Will be CC to other people, right?
well, I mean,
It'll be sent to the usual people.
I'm
who
just
send
thinking like,
all
are we
our-
gonna get, are we going to then, will we want to do this again for the New York City schools? For other public agencies to promote equity and inclusion efforts? Beyond just deciding who we're making investments for. Does that make sense? I guess
It's a good question.
I'm just wondering
Yeah.
why this is,
Well, we targeted this because.
and why we're a local community board, and so this is like a very macro thing for us to be.
But it's a New York City
It's a
thing,
New
very
York
much.
City
Of
thing,
course
and
it
it has
is.
the
Of course
most
it is.
impact.
Exactly.
But
That's the
so
one.
it's a discussion we
We have
had
the
just
most
before.
leverage, right?
Yes.
It's a $280 billion fund.
So the argument is that it has the most impact over everyone's lives, whereas schools just, or the police
I
department,
I don't believe that anyone thinks at this point that the police department, or the schools department is at risk of losing its.
But
their
because
efforts.
this deals with the pension fund and private,
Correct.
the private sector. Okay,
Yes.
that was what I just wanted to make sure.
Sheldon.
why we're-
And having spent 54 years public education, you're never going to have things done in an equitable way. It's so political and so
Shelley, let's chat.
No, it's
Yeah,
very
let's
important.
not go there.
Very important.
Shelley, I thought mom was a retired teacher. I don't dispute with that. I just,
Okay.
my question is answered, and I think you answered a lot, so.
Stephen Meyer.
That's right, Stephen Meyer.
I'm sorry, go ahead.
I move to vote on this particular.
Second.
Hang on a second, I haven't finished my
Okay.
question. We're not, so I
Just looking at my watch.
No, so real quick, I am in support of this. In fact, I almost wish we could be even more emphatic and more detailed about it. The one piece that I think is really important that the pension fund, which I think we said was 280 billion. Is that
Yes.
right? Which is the power of the purse. That's why we're doing this, right?
Exactly.
So that's, you want to hit someone, you hit them in
That's
their
right.
wallet. And I'm all for this. Of course, the controller's office, the chief investment officer, their fiduciary is income producing. I believe that DEI actually will have wonderful results, and I believe it's beneficial in many, many ways, including
So what's the
profitability.
question?
Thank you, Roberta. The question is there something in here that does not conflict and assures that still the fiduciary responsibility is income and increasing? Because that is the mandate of the controller.
They legally have to
They
do that.
legally have to do that.
Yeah.
So I don't, that's why they put it in
They
the.
don't, they
Minimum
don't set
the
the
conversation. Yeah, I think
And
it's.
last year they did 10% based on the June
Then ask and answer.
24 fiscal year.
Yeah.
The question's been called?
Yep.
Okay, do you want to manage the vote or?
All those in favor?
No, because you-
Oh, I was gonna say,
since you're-
committee members only, all those in favor? Who's counting?
Somebody count, please.
1, 2,
Max
3,
is counting.
4, 5, 6,
Roberta's counting.
7, 8, 9, 10, 12, 13, 14, 15, 16.
No.
No.
I got 16 with Seema.
And Seema is, you got Seema too?
Yeah, I got 16
Okay.
with Seema.
So it's those opposed? Those abstaining? And those for, I guess, for cause 0. And
Non-committee members? In favor? Okay. Thank you.
Thank you.
Thank you.
Thanks,
Kevin.
No, it's just like, no.
We don't have a great deal of time left if we want to keep our record of short meetings intact. Can I maybe do this? Can we spend 10 minutes on the issue of the survey and the homework I asked everyone to do? I'll explain kind of why I thought that was a useful piece of homework, and we can figure out what the next steps around the work on our survey, which I think is very, very rich in terms of telling us a lot about the way people on our board feel about their experience. But I think the game is changing for us. We have never before had to think about how things are going to change when members are here for essentially 8-year terms and then leave. In 2 years, we will lose, by my count, roughly 13 people who are core to the historical, knowledge of this board and how it operates and what it has done. It is now when we have to begin to think about how this board becomes different over the next 2 years, and it will be very different in time, and set that in motion for the board members to follow us. And I felt that the cycle of service image that was in the webinar by Jeremy Block that I asked you to look at really begins to do that. And I think many of the elements of this cycle about how you do onboarding, how you structure service, how you structure essentially the preservation of the work and ensuring that it is that you're managing the knowledge of the board in a way that it is not lost when people leave. And even the fact that you have perhaps an alumni program as people begin to move off the board, but still are very committed to and interested in this community. All of that makes sense when you still think of it as a cycle that we are trying very hard to put together. I think we have worked on elements of this, perhaps not as focused on how it all hangs together as this particular webinar developed it. But I do think that there are pieces we have not done. And those pieces are the ones we should be focused on, because many of them begin to answer, if we do work in those areas, a lot of the things that people complained about on the survey. access to information. A lot of questions arose in the survey regarding how do I find out about land use? I need somebody to give me information. How do I get information about this, that, or the other? A lot of that seemed to me to reflect the fact that even though many of those documents exist for people to reference, they don't know it. They don't know where to go for it. They don't see it. So establishing essentially repositories for data that people are well aware of, know where they are, and that they are curated by the committees and by the officers on the executive committee where relevant, that is a huge lift for us to begin to do right now. And I also was thinking that I would very much like to develop, as we are losing this year, a number of people who've been with us for a significant amount of time, that we establish some kind of alumni linkage. I don't know what that should look like. I don't know how we should do it. Is it a newsletter? Is it communication? What should it be? What should it look like and feel like? And one thing that perhaps we could do in this short period of time tonight, obviously we're not going to get deep into these issues this late in the meeting, but are there people here who would be willing to do the deep thinking that is needed around what an alumni linkage for this board would look like? And, I don't need people to raise hands this minute, but I would ask that if you are willing to do that work and to meet with a group who are volunteering to do that, give me an email, and I will be happy to support a group forming around that particular assignment. And it seems to me this is the time to do it. And we have a first crop of alumni that we could begin to work with on how to keep them engaged.
Can I ask a point of information question?
Sure.
How much is the borough president's office thinking about this at all, or is it just being done board by board?
I think that, they obviously are concerned about, about what happens when we actually have term limits kick in 2 years. They are trying to make sure that they talk to us about, well, what are the skill sets that your board will need? And they've had those conversations with me and with Max, and we've tried to give them a general feel for where we're concerned about losing expertise. But I don't think that they're creating any services, let's put it that way, around this.
Because I wouldn't want us to go through all this effort to do something and then have, from a top-down perspective, maybe.
No, I don't think that's good.
You mentioned it in the training.
Yeah,
Right.
yeah.
I don't think that's.
I think it's a great idea for us.
I do think that a lot of the information that we wanted to make available to people exists already. I noticed there was in the survey a couple of people who wanted some training around Robert's rules and parliamentary procedure. There's a ton of stuff on YouTube about that. We should figure out what's the best one or two and make them accessible to our members.
And
the handbook.
Well, but the handbook, I'm looking at it and we're gonna make some changes, but obviously if people had questions about land use, they didn't really look at the handbook.
Right. And there's a webinar that.
Because the handbook it's very, very precise. That's the one thing Louisa did very, very well, is she wanted to put that in, including Mueller. The other thing is people are not looking at the district needs, so they're not getting a sense of that. So, I think Kevin sent me what Board 11 does, and I spoke with Max about it, and someone from the office is gonna help, so we can put in those hyperlinks, so you can click on something, which might, instead of reading the whole handbook, you might just.
There's a lot of systems stuff here and Alex.
But I think, during the training, possibly, and maybe do a retraining for the rest of us as to what materials are available and how useful they can be.
So two things. One is, I had envisioned, just to, again, try to make this short. I had envisioned that every committee would have, as it has now, a Google set of folders that they structure and that includes information you believe that those committee members on your committee should be aware of, right? And that somebody monitor that and structure it and develop new folders as necessary, and that be part of the job of the committee co-chair, right? But there's also the need to have something that's public facing. What do we want those in our district to know about our housing and land use operations or our transportation committee operations, right? So there needs to be a public facing piece as well that is a repository of information. So getting those things launched is part of developing this cycle of service, I believe. But the alumni thing is something, and a lot of that's sort of in process. And thanks to Max and the office staff, the folder system for on Google for committees, I think, is beginning to function in exactly the way we hoped it would. But the alumni piece is empty. Yeah.
So one thing that I think might also connect to some of the things that folks in the survey were saying they wanted help with is, I think it'd be interesting to ask alumni to do a short one pager on an issue that they brought to the CV and brought to a resolution. Because I think something that a lot of people are unfamiliar with when they show up, everyone joined the community board to do things for the community, right? And we all have specific issues that are important to us. But I think sometimes it feels hard, how do I actually do something? But I think we've got great examples from, we had a great presentation at Housing and Land Use about Riverside South, right? Which is a huge project that a number of people worked really, really hard on for a really long time, right? Maybe that's a bad example of this, but a project about how we got this bus stop's location changed, or how we got a loading zone, that kind of one page thing that maybe the alumni could put. I think that would be good both internally to kind of get a model for how you do this, but also externally in terms of recruiting new people for the CV to kind of see what we actually do.
Saralee.
Is that like Elon Musk's 5 things I've done this
Oh,
Someone
boy.
who had
And if you don't
respond
respond. Yeah, so I love that we're thinking about this, and I did watch this twice, and obviously, first time and then on your homework assignment. And I obviously the borough president put this forward for us to think about it. So obviously the borough president cares about it. I think that the alumni thing, I want to know more about that because I have concerns about that. It's so subjective. What I think where any board, the voice of the board are resolutions. So I love that we're all on YouTube now. I love that we can sort YouTube. And I love that the trainings that the borough president does are all on YouTube. So I think that we have a natural repository where we can centralize all the resolutions that were passed and all the trainings that were done, all of our meetings. And if we categorize it and it makes it searchable for the outside individuals from community members as well as the board and new board members, that I just think if it's all in an easy, searchable, consolidated place, that's half the battle. And then, of course, they talked about exit interviews, right? When people have left the board, that's something that, we just took a survey of people that are here. We haven't really done too many exit interviews.
I have tended to do that myself since I became chair with individuals. Largely those, I would say, are confidential in nature because people want to unload a little bit. So I have my conclusions I have drawn from them, which I could, actually, they're pretty close to what the survey sort of said. So, you know, but I think that's something we have access to, but you have to be very careful because it's, again, something that we're not gonna, you know, put out in a public way.
One thing that, and I did watch the training was excellent, I thought. The one thing they didn't talk about, and I don't want to use the term, but I can't think of anything that comes close to a succession planning.
Yeah.
We all have different skills that we bring to the board, and if, you know, if somebody's new and they're joining, let's say YEL, because, and they have a background and ultimately an interest to be a co-chair, they can work with the co-chair of YEL or whatever committee to really get up to speed, so that way that knowledge gets
Right.
passed on in real time.
Right.
Mentorship.
And mentorship as well.
Right. Well, I mean, as some of you may have noticed, I've tried to pair co-chairs who are relatively new with co-chairs who are experienced. That's something that we've been moving towards, and I think we're richer for that. Anyway, enough is enough. It's 8 o'clock. I'm going to defer the chair reports unless somebody has something compelling they think they need this group to hear. No? Okay. So can each committee have one co-chair? Please email any resolutions planned for the next full board in April, so that Max and I both know how to build the agenda, because that's a key matter, but we can do it on email. We don't need to do it, you know, here, unless folks have, as I said, issues that they feel this group needs to hear.
Can I make a public service?
Sorry, sure. Yes, go ahead.
All the committee chairs have until June to finish their initial DNS and budget priorities. We sent out a letter, Max sent out last week with the items that have been completed and the items that have been completed. So use that as your jumping off point. Thank you.
Okay. Do I have a motion to adjourn?